Member for Latrobe. The question now is that the amendment be agreed to, and I call the honourable member for Greenway.
Thank you, Mr Deputy Speaker. I come to speak on this bill with a long interest in this issue as both a practitioner and someone concerned with observing the way in which technological change is matched, or in many cases not matched, by regulation. And it is true that we do have crime. We have new forms of crime that have evolved, and the interception and access regime that we have in Australia has revolved sometimes in consequence to and sometimes in spite of different evolution that occurs in our society. And it used to be a plain differentiation between whether a matter was covered purely by the Commonwealth interception regime or the listening devices legislation of the various states and territories. And 15 years ago, this was actually probably one of the most common and complex questions, and it was all concerned with voice, whether or not this particular voice communication was covered by a state or territory regime. And if we even look at the way the interception regime was enacted at a Commonwealth level, it was essentially drafted on measures to deal with SP bookmaking, which of course has now gone by the wayside. So I think that just gives you an illustration by way of background, the way in which this area of the law has evolved. And as someone who also worked in-house advising an operator on very complex issues relating to warrants and the law enforcement and access regime, in particular during a very significant incident several years ago in Sydney, which was a highly anxious time for all operators. It's an area in which, as I said, I have had an enormous interest. And just to set the scene also, I think it would be worthwhile quoting from a paper that I co-wrote in July 2008 for the third workshop on the social implications of national security. And I ended with these words: given the use of warrants is already extensive in Australia, perhaps it is time to review whether the legislative framework and the associated regulatory regime represent the appropriate balance between the needs of law enforcement agencies and citizens. After all, the probable cause test is not so onerous that it could not be applied in Australia, and members of the Administrative Appeals Tribunal will likely be just as available to the relevant agencies as they are for the existing warrant regime. So they were my views in 2008, and I have been consistent on a couple of points in that regard. The first is in terms of highlighting this is about balance, this is about proportionality, and in particular, as we implement this regime, about oversight, about scope. And I think it is also worth remembering that even when in opposition, members of this government were some of the most vociferous opponents of the notions contained in this bill. The current Minister for Communications openly spoke of his grave misgivings on data retention. We had the member for Moncrief, who said that he thought this proposal akin, frankly, to tactics that we would have seen utilised by the Gestapo or groups like that. Now, I don't mention those to in any way take away from the views that have been expressed in the past. And indeed, many of the reservations, the sentiment, is something that I certainly share. But I think where we are today, the task at hand is to improve on an extremely flawed bill that was presented by that very person, the Minister for Communications now, in October last year. And by no means do I believe this bill is optimal. By no means do I think it's optimal. I think it has been improved by process, and even in some respects there have been some positive and possibly unforeseen consequences arising from its recommendations in areas that will affect privacy, including the recommendations relating to privacy alerts. I want to make it clear, Mr Deputy Speaker, that citizens, residents of Greenway, and there are many of them who've contacted me, have been concerned about the way in which this bill may influence their rights. And I have received many thoughtful and numerous direct representations from constituents, a broad cross-section of people, citizens who value their privacy. And one thing I think we can say, the only rule I think that is possible when trying to predict technology and the interplay with regulation, the only rule I think we can have is never underestimate technology. Never underestimate technology. But I do want to turn to some of the substantive issues, Mr Deputy Speaker, and one of the most fundamental being that, when I'm talking about the improvements in this bill is that we now have a recommendation and supporting amendments that a data set actually be defined, to actually give parameters to what we are talking about here. And this was not in the original bill. There was a series of recommendations relating to the data set, a comprehensive series, including, in fact, the most fundamental primary first item of recommendation here was that the bill be amended to include the proposed data set in primary legislation. And it goes on through recommendation 3, for example, how to declare items for inclusion in the data set. There's even a series of recommendations that the explanatory memoranda be amended to make certain things clear. Now, why is that important? That's important, of course, for interpretation as extrinsic materials when looking at how these provisions will end up being applied in practice. So I think that is probably the most fundamental change from the outset to be improving on these measures. The other issue that I think is important to mention, and it does give rise to some other substantive provisions in the recommendations, is the issue of proportionality. And it's one that has the committee that looks at this from a human rights perspective, the Parliamentary Joint Committee of which I'm a member, raised these questions in its initial consideration, and they were very serious concerns about proportionality, particularly relating to the time for retention. Now, I don't have visibility, entire visibility of the deliberations that occurred within the committee, so what I do have to go on is the report and the recommendations in Chapter 4, and looking, for example, at paragraph 4.39, where it mentions that ASIO and the Attorney-General's Department advised the committee that the proposed 2-year retention period is the result of, and I quote, extensive engagement between the AG's department, law enforcement agencies and national security agencies. And I note here in particular, ASIO had advocated for a retention period of up to 5 years. However, the department concluded that the shorter 2-year retention period would be proportionate to the legitimate ends of safeguarding national security and public safety and the enforcement of the criminal law. We also, there was clearly evidence also in paragraph 4.41 from the Australian Federal Police, emphasising that while the majority of criminal investigations relate to relatively recent conduct, complex and serious investigations often require access to telecommunications data from considerable time ago. I do want to stress again, Mr Deputy Speaker, that in spite of that, I recognise that people, citizens will still have concerns about that 2-year period. I do want to go to an issue that I believe will end up having substantive implications in the immediate and long term, and that is the issue of costs. Now, PwC commissioned a report estimating capital implementation of between 189 and 319 million. That's capital expenditure. And it is still unclear how smaller operators, especially smaller ISPs, will meet their obligations. I note recommendation 35 of the recommendation here that having regard to the regulatory burden on small providers with an annual turnover less than 3 million, there's a recommendation that the bill be amended to require all service providers to be compliant in respect of retained data with either the Australian privacy principles or binding rules developed by the Australian Privacy Commissioner. I point in particular to a letter from Communications Alliance signed by the CEOs of its member companies, including Telstra, Optus and Vodafone Hutchison, who have pointed out the need for clarity as to the government's intention to provide a contribution to upfront capital expenses that may fall on the industry following the anticipated passage of this bill. And they note the government has variously indicated it will make a reasonable or substantial contribution to these costs. And it's evident, I quote here, it's evident that the extent to which the government's contribution falls short of the total cost to industry will determine the quantum of additional cost to be absorbed by carriers or carriage service providers or passed on to Australian telecommunications users. This is significant. This is significant for a number of reasons, not only because of the potential implications for smaller operators, many cases small businesses, the implications for innovation, but also I would point out, we had earlier today the announcement of another red tape repeal day, and on its own website this government claims annual savings of over $2.1 billion in what it calls reduced compliant costs for businesses, community organisations, families and individuals. The reality is, Mr Deputy Speaker, this scheme will cost. It will cost. It's just as important as compliance measures, which we often take for granted costs, and I will watch this with interest. And I'm not alone in having concerns about these cost issues. It was interesting to read a recent opinion piece from the IPA, an organisation with whom I don't think I agree on much, noting Communications Minister Malcolm Turnbull will preside over the largest increases in the regulatory burden since the telecommunications market was liberalised 2 decades ago, and I think that's probably right. And again, that's exactly what Minister Turnbull said in his 2012 Alfred Deakin lecture, and I quote, "Leaving aside the central issue of the right to privacy, there are formidable practical objections. The carriers, including Telstra, have argued that the cost of complying with a new data retention regime would be very considerable, with the consequence of higher charges for their customers." Mr Deputy Speaker, another extremely vexed area is, of course, that of the implications for journalists and the flagged amendment on journalists and their sources. And it's pleasing to see that the opposition's intervention in this matter has led to what we hope will be positive results in this area. It's frustrating it has taken so long. But I will note, for example, the concerns in the community and the sector, as the head of the Internet Society of Australia, Laurie Patton, told The Australian on March 7 before the Prime Minister flagged his back down on this. There is no certainty that an effective mechanism to protect journalists and their sources can be retrofitted if the data retention bill is passed in haste. This will be a significant issue. It will be a significant issue even for some of the most fundamental definitions. In the Evidence Act, for example, we have definitions of what is an informant and what is a journalist. Journalist means a person who is engaged and active in the publication of news and who may be given information by an informant, which is separately defined, in the expectation that the information may be published in a news medium. Now, I look forward, I'm happy to stand corrected, but I actually haven't seen the amendment in its final form on this issue. But many constituents have raised with me the issue of whether this will be a narrowly defined definition of a journalist. Will it be the same as in the Evidence Act? And considering that so many of us are participants in a scheme where we participate in the new media as commentators, are we all active participants who would end up being covered? And can we define this separately for the purposes of an Act, so thereby have a different definition of journalist for one Act or another? And this is no trivial matter. Even as I see this morning Chris Merritt writing very succinctly on this issue of the relationship between the metadata bill procedures and the Shield law provisions, and he well encapsulates the conundrum of benchmarking the tests that are in the Shield laws with those that already form part of the Evidence Act. And he ends by saying, unless these requirements form part of the metadata bill, the Shield law and the values championed by Attorney General Brandis in opposition will become irrelevant as authorities turn to the metadata scheme instead. Mr Deputy Speaker, as I indicated, there are, I think, some positive outcomes arising from the recommendations. For example, the original bill did not provide for individuals to access their own data. There was no provision for the encryption of data, even though this had been recommended in 2013, and the privacy alerts mechanism is certainly welcome. I'd like to end, Mr Deputy Speaker, just by quoting from one of the people who gave evidence towards the committee. The threshold proportionality issue of whether retention of data that enables pervasive surveillance of all Australians is a reasonable and proportionate response to the threats of terrorism and serious crime remains itself largely untested and therefore controversial. It certainly is, Mr Deputy Speaker, but I think this parliament will have a very important role. After this debate's finished, it is a matter of us walking away. Parliament is going to have a crucial role in the operation and the oversight of the provisions of this bill which will be enacted. We will have responsibilities that I believe our citizens expect us to take very seriously.
I thank the honourable member for Greenway.